The next case on the calendar is Perez versus American Changer Corporation. Yes.
Thank you, Your Honor. May it please the Court, my name is Bill McCabe. I represent the appellant and the claimant, Oscar Perez, and I'll reserve 3 minutes for rebuttal. In this case, we submit the Judge of Compensation Claims erred in finding the claimant's August 8, 2008, March 5, 2009, and May 29, 2009 petition for benefits were barred by the statute of limitations. First, we contend the statute of limitations didn't run at all because the December 4, 2005 and the October 2, 2006 petitions for benefits, which were timely filed, were still pending at the time these other petitions were filed. There was a mediation conference on February 6, 2007, which is after those two prior petitions for benefits, which indicates the parties resolved all issues except attorney's fees, but the attorney's fees issue was never resolved. Those petitions were never dismissed, and they remain pending. So we submit that the statute of limitations never ran at all. There's no exact case directly on point with this particular issue as to whether a petition for benefits...
Mr. McCabe, I mean, would an attorney be serving the best interest of their client then if they, I mean, let's say that you recovered medical mileage, a relatively small benefit for your client, obviously important, but you know, not huge monetarily and not a huge fee. So the attorney never takes that fee, never, because the fee can't be given unless you go before the court and get the court to award it. And now you've given your client a lifetime of coverage on his workers' comp claim. He never has to worry about the 1 year thing and then getting the treatment. And, you know, I mean, he's golden for the rest of his life, right?
Well, the insurance company, if a year goes by and no action's been taken on a petition for benefits, can move to dismiss it for failure to prosecute. That's a remedy that they've got. The other remedy, too, of course, it wasn't applicable in this case, but the new Q rules that they passed effective October 31st, 2010, does allow an employer carrier now to call up an attorney fee petition that's outstanding. But at the time of this case, the attorney fee issue was still outstanding. Those petitions were not dismissed, so we contend the petition, the statute of limitations never ran. The second argument we have is that the employer carrier waived the right to rely upon the statute of limitations because they failed to advance that defense in their initial response to the August 8th, 2009 or 2008 petition for benefits. The adjuster stated that he didn't receive that petition for benefits until they went on DOA to do a check on December 29th. And he stated that he then responded that day and asserted the statute of limitations. The problem with that is they never put their response in evidence, and if you look on the DOA website, it indicates their response wasn't filed until January 20th, 2009, so there's no evidence to support that statement. They did send a letter not objecting to a continuance of a mediation, and we contend that was their first response to that petition for benefits. And I would point out that this defense, or this rule, is apparently pretty strictly construed. I pointed out the Batista versus Public Supermarkets case. It was a prior statute of limitations issue, and that, at the time of that case, a carrier had to advance the defense of statute of limitations at the first hearing. In that case, the first hearing was a motion to compel production. It wasn't advanced, and hence they waived the statute of limitations defense. So it's a strictly construed statute, and we submit they didn't advance it in their first response. The third basis that we allege is that the employer carrier is stopped from raising the statute of limitations as a defense because they failed to provide the informational brochure to the claimant.
Well, there was testimony that it was mailed out, right? I mean, the claims adjuster testified that it was mailed out.
The claims adjuster stated, based on what he stated was when a new claim is opened and typed into the computer types in a statement that says brochure sent. And that statement's typed even before the actual brochure is sent. But the problem with this adjuster's testimony in general is that he really does not know what the procedure is. The brochure, if it's sent at all, it's sent from a Boca Raton office where he wasn't even at. And he was asked questions, for example, on page 70 of the record. It says, so you have no idea how that system works, correct? And he says, I just told you, right. And then He's asked, can you give me the name on page 71? Can you give me the name of the person or anybody who's in charge of sending the stuff out? I don't know who's up there anymore because the company got bought out, so I don't know. You'll have to call and find out yourself. And then when you send out a brochure, or allegedly when you're supposed to send a brochure, is it supposed to go with a cover letter? Answer, I don't know back then. I don't remember. Shouldn't you have a copy of the letters that went to the claimant? I don't know if they had a letter.
Doesn't a lot of this go to the weight of the testimony? I mean, clearly a fact finder could reject it and say, I'm not persuaded, but...
Well, when their adjuster states he doesn't know how the system works, I don't see how that can possibly be competent substantial evidence to even support a routine of the office.
I mean, I can tell you that if I send you an email, I can tell you I sent you an email and I'm pretty confident that you would get it, but I don't know how the whole system works. I mean...
I submit that this adjuster's testimony does not support the routine of the office because A, he wasn't even there, and B, he doesn't know how the system works according to his own testimony. Now, even if, let's assume that you feel there's competent evidence to support that a brochure went out. No brochure was ever placed in evidence in this case. No brochure was attached to this man's deposition.
Does it have to be?
Well, how do you know what the brochure says if it's not in evidence? We don't know if a brochure was sent. He claimed the October 2003.
Is there a case law that says that the brochure has to be introduced into evidence whenever it becomes an issue?
Well, I would submit, no, there's not a case that says that. But if you're trying to establish that a brochure was sent, which advises the claimants of his rights and obligations under the workers' compensation law, and it's being disputed, and there's no brochure that's attached to the man's deposition. They tried to put the brochure in evidence at the hearing, and the judge sustained the objection on authenticity and hearsay. So there's no evidence of what the brochure even said. So I don't know how there can be competent evidence that the claimant was properly advised of his rights and duties under the workers'
Does what it say matter if you're contesting that you never got it? I mean, in other words, it could be the most wonderful document in the world, or it could be the worst document in the world. But that's really not your defense. I really wasn't advised. I got this, and this is not what it's supposed to be. That's not your defense. Is really, I'm assuming, we never got it.
Well, if you're trying to refute a claimant's statement that he never received the brochure and was never advised of his rights under the statute, I would think that you would have to establish, number one, that you sent the brochure, and number two, that the brochure did advise them of their rights under the statute. In this case, I submit they didn't do either.
Which is your strongest statute of limitations argument? The brochure, the waiver, or the estoppel?
If I have to do them in a pecking, I think they're all very strong. But if I have to do them in a pecking order, I would probably say estoppel first. I would probably say pending petition for benefits second, and fair to timely or fair to raise it in the first response is third. But I think they're all strong. Now, the second issue that we have problems with also is...
And if we accept... I'm sorry, but if we accept the JCC's finding on the second issue, the first issue doesn't matter, does it?
Let's, on the second...
I thought you said that the doctor... it wasn't...
Oh, that's what I was going to get to. That's my next argument. And yes, but in the second issue that we have is the judge found, in addition to the statute of limitations defense, that there was no medical evidence offered to establish continued medical treatment with Dr. Azar was medically necessary or the work-related accident was the major contributing cause of claimant's current complaints. The judge made that finding. The problem we have with that is that was never an issue. The employer carrier never raised that defense. They didn't raise it in their pretrial statement. They didn't raise it in their closing argument. They didn't raise it in their memorandum of law.
So is your argument then that you didn't have due process the opportunity to prove it better?
Absolutely. That's argument A. Absolutely. Because if it's going to be an issue, we're entitled to know about it. And I cited that Vargas case that says that.
Now, what about the fact that obviously the claimant has the burden of proof to get benefits, and he has the burden to prove each element of it, and in essence, the employer carrier could come into the courtroom completely unprepared and file their fingernails and let you do whatever you need to do, and you could still fall short.
Well, the judge stated at the beginning of the hearing that the only issue was whether the statute of limitations barred the claimant his right to continued medical treatment. Now, if that's the only issue, and the claimant presented evidence on that issue. It seems like it's a denial of due process to say, you know, you're right on that issue, but I'm going to deny medical because you didn't prove medical necessity. Well, if we had known that was going to be an issue, you know, we would have taken steps to that, perhaps. But secondly, I submit that there's evidence in here to show it's a medical necessity anyway. And that evidence is that this claimant has a 7% permanent impairment rating as a result of this compensable accident.
But we couldn't make that finding here, right?
I beg your pardon?
We couldn't make that finding here, right? I mean, that's a finding of fact, whether or not there's a necessity. I mean, we couldn't make that, could we?
Well, I know you don't like to make findings of fact. I understand, but I do have a case. I cited that Homer case that states if a claimant has a permanent impairment, they're entitled as a matter of law to ongoing palliative care. So if the parties stipulate that there's a 7% permanent impairment rating, and you got the Homer case, then we would submit that that establishes that the claimant is entitled to ongoing medical care. And that is all in the record. So if it was an issue, I think the claimant proved it anyway. But I'd like to reserve the rest of our time for rebuttal.
Good morning, Your Honors. My name is Rayford Taylor. I am here on behalf of the employer carrier. We are here to ask that you affirm Judge Hogan's rulings in all respects. If I might, I'll address his arguments in the priority in which he put them, if I may. I think the record is very clear that well, first of all, Judge Hogan found that the employer carrier met its burden of proving that it, in fact, had sent out the informational brochure. You are correct. It is irrelevant what the brochure said. We are talking about a brochure in the year 2004 when this action happened. The Division of Workers' Comp in those days would have changed the brochure from time to time as the law changed, and that would have been the one the carriers would have had to have used. We're now in trial here in 2008, 2009, or 2009 rather, 2010, and any brochure put into evidence might have been different than the 04 brochure. But I think we met our burden of proof. We established what the procedure was. The law is very clear that on the business record exception, you don't have to prove every single element of the transaction from A to Z in order to establish the routine practice of the company, and that the file, according to the adjuster, showed that routine practice was followed. He doesn't have to know every person. He doesn't have to know who actually put it in the envelope and mailed it. That's not what the test. And Section 90.406 of the Evidence Code makes that very clear. And when you look at the committee note, it's even clearer that if someone comes in and testifies to the routine business practice of that company, and that the file reflects it was done in that case, you don't even have to prove it was actually even done. Plus, in addition, Judge Hogan found she didn't believe the claimant, that he didn't get the brochure. He seemed to get every single indemnity check, but he testified he never got another piece of paper in 4 or 5 years from the carrier on any aspect of his case. And Judge Hogan made a factual finding that it was unbelievable to her that that would have been what happened. But he didn't get any letters, he didn't get any notices about doctor's appointments, and he got absolutely nothing but indemnity checks, all of which went to the same address the brochure went to, and the same address that the testimony was that all of those other letters, correspondence, what have you, went to. So we think we established that the brochure was timely sent, that it was sent, and therefore the burden rose to the claimant to prove by clear and convincing evidence that we did not do that in order to defeat our statute of limitations defense. And what the judge found was not only that he didn't reach clear and convincing, he didn't even reach preponderance, according to her order. And I think there is ample CSD in the record to support those findings, and we think you should affirm on that basis alone that we met our burden.
But you could have waived your statute of limitations.
In terms of not responding timely?
In terms of, we obviously there's the argument of the pending petitions, but then there's the argument that your first response in this case was the mediation discussion.
Right. And I can address that now. He said that was his third strongest, so I was going to do that.
Okay, I'm sorry.
That's fine. I'll address it now. I think it is very clear that, first of all, the statute requires an initial response to the petition for benefits. That's the statute that applied. It is clear that the carrier did respond to the first petition. The judge found that the carrier did not get the second petition, the August one, until December, and that a response was filed indicating statute of limitations was raised. Their argument is, regardless of when it was done, my law firm's letter to opposing counsel seeking an emergency order for a protective order to avoid going to a mediation on that petition, because apparently they didn't get notice either, our response was, we don't object to you resetting the mediation because we didn't get the notice either. Now, I don't see how that remotely reaches the statutory requirement of first response to a petition for benefits. And I think there is ample evidence in the record to support the judge's finding that we responded to those two petitions and raised the statute of limitations in conjunction and in compliance with the statute. So that's our position on that. Now, he cites the Homeler case as two cases, really. One, he cites the Homeler he cites Curtin and he cites Batista. The Curtin case, that the employer carrier filed a document called a response to the petition for benefits. It apparently was not done on the agency form, the DW form that's ordinarily used. But they referred to the petition and they raised some defenses, one of which was not statute of limitations. And then they subsequently filed the form entitled response to petition and raised the statute. And this court said, no, your first response was really when you reacted directly to the petition. Well, that's nowhere near our saying we have no objection to you moving a hearing. That doesn't remotely get close. I mean, why would we have even dealt with the merits of the claim when we waived our objection to the mediation going forward when we didn't know about it either? I don't see how he can make that argument and equate those two pieces of paper, in effect, under the Curtin case. And Batista was a different statute. And to begin with, first of all, there was apparently a hearing which the carrier alleged we didn't get notice of, or they didn't get notice of, and they tried to raise the statute of limitations 10 years later. This court said, no, that's not going to work. You've got to, first of all, the statute required it be done at the first hearing, which they claimed they didn't get notice of and obviously didn't attend under the facts in that case. But the court said, no, we're not really going to accept that and let you raise the statute of limitations 10 years later. One was, in this case, was done immediately, and the other one was done several months later when our client got a copy of the petition. And sometimes those petitions don't get to the carriers, and they pull them off the door. And Judge Hogan found that was appropriate in this case, so she believed the testimony that that's what happened. Now, the pending petition claim, it is clear by the time of the filing of the August petition that the May 2008 petition had been dismissed. In fact, I'm sorry, there was an 2006 petition that was dismissed in 2007, by the time of claimant's prior counsel. So there were petitions filed over a period of time, from 2004 until about 2007. Every one of those petitions were dismissed by Judge Breckner, save that one, because they'd all indicated that all the issues had been resolved. And when she dismissed them all, there was an objection filed by Mr. Perez, the attorney at the time, prior counsel. Wait a minute, there may be fee issues out there. So the order was amended to indicate that all the petitions for benefits to the claimant were gone. But if there was any attorney's fees due, the judge reserved on that. Now, the argument advanced at trial, and being advanced here, is as long as there's some theoretical entitlement to an attorney's fee out there, then there is a pending petition, and the statute of limitations cannot, does not, and will never run.
Well, now, attorney's fees are a benefit to the claimant. An employer carrier paid attorney's fee is a benefit to the claimant, correct?
Only as to a finding of entitlement, not as to amount. This Court has said that finding entitlement to fees is a benefit to the claimant because that means they're not paying their lawyer, the carrier is. But the amount of the fee is not a benefit to the claimant once entitlement is established. In this case, there's only two ways Mr. Perez could get a fee. File a lien, which means he's indicating he's due a fee from his client.
That would be a settlement situation, though, wouldn't it?
Well, from somebody, from the claimant for something. I may have done something that got him a benefit that he owes me a fee for, and I would get that out of the settlement. Or he could have filed a verified petition. He didn't do either. At least the record doesn't reflect he filed a lien.
But if this one remaining petition, I'm sure it asked for attorney's fees. I think they routinely do. And in fact, they go to mediation, or however that was resolved. Right. And the benefits are provided. And there is a statement that all issues are resolved except the attorney's fee. That is, in fact, a benefit for the claimant, isn't it? And it is in that petition.
Only as to entitlement, yes. I would agree that would be the case. Theoretically, all you can say is if you go to mediation and the parties agree that all benefits have been provided, and claimant's counsel will not concede they're not due a fee, then there's only a theoretical right to a fee, because you still have to go in court and prove the carrier was late, that they didn't comply with the statute, that they didn't do the other things that create entitlement under 440-34. Well, the only petition in October of 08, prior claimant's counsel asked to have everything related to the May 08 petition dismissed. He said everything had been resolved. He didn't say everything but attorney's fees. He said everything. So, again, we're back to the point where we're dealing with a theoretical attorney's fee entitlement. If it's a lien, we cite the two Zaldivar cases which say that's an equitable benefit to claimant's counsel. It's not to the claimant. So, arguably, that wouldn't preserve the statute of limitations as to the claimant. So, what about an attorney's fee from my client? There's no verified petition pending in that case.
Can Mr. Perez come in now and ask for a fee?
Pardon?
Could Mr. Perez come in, go before the JCC now and ask for a fee? Since the rule hadn't been changed that let us push a fee to a hearing, he can wait years and years to do that. And we may have a laches defense. We may have, if we stipulated to fee entitlement any of those petitions, prior petitions, which there's no evidence in the record one way or the other, theoretically, he could come in and file a verified petition, and we would have to deal with the amount. But if it's an amount, again, it's not a benefit to the client. It's only a benefit to Mr. Perez. If he wants to come in and establish entitlement, they rely on two cases, one called Aerie versus Walmart, and the other one is that Kimmons Court case versus Truck. I don't think either of those apply. In Aerie, the court said you can't dismiss, this court said you can't dismiss a verified petition because it sat too long. You really need to do a motion to dismiss for lack of prosecution, which hadn't been done in that case. Well, there's no verified petition pending. If there had been a verified petition pending, the statute may very well have been preserved. It might very well have. But there was no verified petition. And again, when you look at Kimmons, it said the same thing. The parties stipulated to fee entitlement. And a petition was pending for amount. And first of all, that's a PCA opinion. But Judge Urban wrote a special concurring opinion that talked about the fact that there was a petition pending for fees, and therefore that seemed to keep the statute going. I understand that the argument on the other side is it doesn't matter whether there's entitlement or amount. As long as that exposure is there, then there is a, quote, pending petition. If you adopt that interpretation they're presenting to you, then there will never be a statute of limitations defense ever again, as long as those petitions hang out there. And the carrier doesn't have any ability to dismiss those petitions. The claimant's counsel doesn't want to dismiss them. The judge dismissed them because they've been sitting out there for a long time and nothing had happened.
And she did clarify, Judge Breckner clarified, that might still be some fees out there, if any, but that hadn't been acted upon.
You don't have much more time.
No.
And if there were a problem, and the statute of limitations defense did not apply, did the judge properly reach the issue that the claimant was not entitled to any medical benefits?
Very briefly on that, Your Honor, whether we raise a defense or not, it is our position that they have a burden of proof. And that burden of proof comes up two ways. He argues that palliative care is palliative care, and all I have to do is ask for it, and I get it.
So if the judge says before the hearing the only thing we need to discuss is the statute of limitations, is claimant's counsel then at the position to say, well, Judge, I don't care what you say, I'm going to go ahead and present all this evidence as to entitlement and need as well?
Well, he went ahead and put it in. He has client testify about his injuries and why he wanted to go back to the doctor. The medical records were put into evidence. They didn't need to be put into evidence if it's a statute of limitations claim about the fact that Dr. Azar had seen him in 2007 and said you can come back when you want to. There was no indication he needed any ongoing treatment.
So your argument is that they did in fact make the arguments that they needed to make?
That's correct.
Because
that is our position. They did not carry their burden of proof under either 440.09 or 440.13. Regardless of the statute. Thank you.
Just briefly, as far as whether the brochure was sent out, I cited EIG versus Insurance Company of North America, where the court said, while it is no longer necessary that a party claiming routine practice offer evidence that the routine practice was followed in the particular instance at issue, the party does have to prove by competent evidence what its routine practice is. And we submit that getting testimony from a person who doesn't work in the office, has nothing to do with sending out brochures, and has no idea how the system works is not competent evidence of any kind of routine office practice concerning sending the brochure. Now, the judge, as far as the first response from the carrier to the petition for benefits, the judge found that the first response the carrier sent was a denial based on the statute of limitations based on the adjuster's testimony when the adjuster said he sent a response on December 29th. The problem with that, the response is not in the record, and DOA shows the employer carrier's response was not sent until January 20th. The judge didn't find that the employer carrier's letter concerning the mediation was not a response. He just found that the response was sent prior to that, and there's no evidence that any response was. Now, as far as a statement was made that the prior petitions for benefits were dismissed, there's no record that they were dismissed. There was an administrative order closing the file on April 18th, which is not again in the record, and if you go on the DOA website, you can't open it. But the claimant objected to it, and that's when the judge filed another order on May 5th saying if the issue of attorney's fees comes up, I have jurisdiction to hear it. So the attorney fee issue was still pending. It doesn't matter whether a petition for attorney's fees has been filed yet. As long as the issue is out there, their petition for benefits remains pending. And then the final thing, as far as the burden of proof, I mean, if it's not an issue in the case, I don't see why the claimant has to present testimony on it. Otherwise, to say, well, it's always the claimant's burden of proof would mean that no matter what the issue is in every case, the claimant's got to establish that an accident occurred, that it was compensable, so on and so forth. I mean, that's just a waste of everybody's time.
If the only fight was on the statute of limitations, then why would you bother to introduce medical records?
Well, part of it is, it kind of goes, I guess, with the statute of limitations claim as to when the last medical treatment was and so on and so forth.
But that's not why it was.
I'm not really sure why the medical records.
I mean, if we look at the transcript, I mean, it looks like, obviously, that they were proving up their current need, or attempting to, obviously. I mean, they didn't persuade the JCC, but it looks like that's what they're doing.
Well, if that's what they were doing, again, I rely on the Homeler case with a 7%. We have a 7% permanent impairment in here, and with a permanent impairment, he's entitled to ongoing palliative care. So, thank you.
Thank you, Jensen. Thank you, Bill. That concludes the court's calendar for today. We are adjourned.